Greetings and welcome back to the lesson. The subject is Introduction to Law and Governance. We're still on the chapter Introduction to Corporate Governance. In our last session, we defined corporate governance. We also laid out the objects of corporate governance. In our today's lesson, we are going to study the principles of corporate governance. Principles of corporate governance. So, candidates, the lesson objective today is that by the end of the lesson, should be able to summarize the principles of corporate governance. And the principles that we study in our today's lesson are the principles that are laid out by the Organization for Economic Cooperation and Development, the OECD. From other books, you may find principles that are different from the ones that we want to discuss today, like the principles of fairness and equity and all that. But today, we will study the principles of corporate governance as per the OECD. And these are the core principles of effective corporate governance. Core principles for effective corporate governance. Core principles. We study the core principles for effective corporate governance as per the Organization for Economic and Cooperation Development. All right, the principles of corporate governance as per the Organization for Economic and Cooperation Development, right? Cooperation and development. Now, the first principle, candidate, is the principle of ensuring framework. The principle of ensuring the basis for effective corporate governance framework. The second principle is the rights and equitable treatment of shareholders. The rights and equitable treatment of shareholders. The third principle is institutional investors, stock markets, and other intermediaries. Institutional investors, stock markets, and other intermediaries. The role of stakeholders in corporate governance. That's principle number 4. Disclosure and transparency. Then lastly, the responsibility of the board. The responsibilities of the board. These are 6 core principles of effective corporate governance as per the OECD. Let's first discuss the first principle, which is the principle of ensuring basis for effective corporate governance framework. Corporate governance framework. Corporate governance framework. You can mark that. Corporate governance framework. Now, candidates, the corporate governance framework should promote transparent and fair markets. Should promote what? Transparent and fair markets. And also the efficient allocation of resources. It should be consistent with the rule of law. And it should also support effective supervision and enforcement. And therefore, effective corporate governance requires a sound legal, regulatory, and institutional framework that market participants can rely on them. Especially the private markets, the private participants. It should ensure that there is an effective corporate governance framework. That's a very important core principle of corporate governance, ensuring a ensuring a basis. So a corporate governance framework should be based on rule of law. All right? It should be anchored in law. And there ought to be effective supervision and enforcement of that law. When that happens, then people can have confidence in their resources that they invest in companies. It should what? It requires, I said, a sound legal, regulatory, and institutional framework which market participants can rely on when they establish their private contractual relations. And the framework candidates, the corporate governance framework typically comprises the elements of legislation, the elements of regulation, the elements of self-regulation arrangements. It also may also include things like the voluntary commitments as well as business practices that are the result of a country's specific circumstances, specific history, and specific tradition. That's principle number one, ensuring a basis for effective corporate governance framework. The second principle is that one of the rights and equitable treatment of the shareholders. Rights and equitable treatment. Rights and equitable treatment. The corporate governance framework should protect and facilitate the exercise of shareholders' rights. Shareholders' rights should be protected. And it should also ensure equitable treatment of all shareholders, including the minority, including the foreign investors, the foreign shareholders, and so on. So an effective corporate governance dictates that the rights of shareholders should be respected, they should be protected. There should also be equitable treatment of shareholders, whether they are the minority or whether they are foreign shareholders and so on. Equitable treatment. They should be treated equitably. Their rights should be respected. Their rights should be protected. And also there ought to be facilitation of the exercise of shareholders' rights and equitable treatment of all the shareholders. The third principle, core principle for effective corporate governance as per the OECD is that one of institutional investors, the stock markets, and other intermediaries. All right? And other intermediaries. These are institutional investors, stock markets, other intermediaries. The corporate governance framework candidates should provide sound incentives throughout the investment chain and should provide for stock markets to function in a way that contributes to good corporate governance. The framework should be one that contributes to good corporate governance, good corporate governance. And candidates, in order to be effective, the legal and regulatory framework for corporate governance must be developed with a view to the economic reality in which it is implemented, because we know each country operates in a unique economic environment, unique political environment, unique technological environment. So whatever the environment, the corporate governance framework should be unique to that environment. And the institutional investors acting in a fiduciary capacity should disclose their corporate governance and voting policies with respect to their investment, including the procedures that they have in place for deciding on the use of their voting rights. Institutional investors, stock markets. Stock markets are markets where the financial instruments are traded, like the shares, the bonds, the derivatives, and so on. And financial intermediaries are like the financial institutions, the banks, and such like institutions. So institutional investors and the stock markets should operate within a certain regulatory environment, depending on the circumstance in which the companies operate, right? The legal and regulatory framework for the corporate governance must be developed with a view to the economic reality in which they are implemented. The fourth core principle is the role of shareholders, role of stakeholders in corporate governance. The role of stakeholders in corporate governance. Stakeholders, candidates, are persons who have an interest in the affairs of a company, like the employees, the government, the potential investors, the lenders, the members of the public. All those are stakeholders. So the question is, what is the role of such stakeholders in corporate governance? So the corporate governance framework should recognize the rights of the stakeholders, and such rights may be established by the law or through mutual agreements. And it should also encourage active cooperation between the company and the stakeholders. The purpose for such a cooperation is to create wealth, to create jobs, and the sustainability of the financial position of a company, what we call the soundness of a company. So stakeholders should be recognized. They should be recognized. They should be appreciated. The role they play in wealth creation, because we know companies do not operate in a vacuum. It's not possible for a company to create wealth without stakeholders. Stakeholders are customers. Stakeholders are suppliers. Stakeholders are financiers. Stakeholders are members of the public, the government. All those parties I've mentioned play a critical role in the affairs of a company towards creation of wealth. One of the reasons why companies exist is to create wealth. Company cannot create wealth in isolation. It has to rely on customers, has to rely on suppliers, has to rely on the government to provide permits, provide licenses, and it has to have employees who can help in the transformation of raw materials into finished products and to pushing the agenda of the company towards achieving the objectives of the company. So corporate governance, we know, is also concerned with finding ways to encourage the various stakeholders in the firm to undertake economically optimal levels of investment in firm-specific human and physical capital. So the competitiveness and the ultimate success of a company is a result of a teamwork that embodies contribution from a range of different resource providers, including investors, employees, creditors, customers, suppliers, and other stakeholders. So candidates, corporations should recognize that the contributions of stakeholders contribute a valuable resource for building competitive and profitable companies. And it is therefore in the long-term interest of a company to foster wealth-creating cooperation among all these stakeholders. And the government's structure should recognize the interests of the stakeholders, should recognize the contributions of the stakeholders to the long-term success, for the long-term success of the company. So it's a very important principle of corporate governance, the role of stakeholders in corporate governance. Then number 5 is disclosure and transparency. Disclosure and transparency. Candidates, a corporate governance framework should ensure that there is timely and accurate disclosure. Timely and what? And accurate disclosure should be made on all the material matters regarding the company, including the financial situation, including the performance, including the ownership of the company, and also the governance of the company. There has to be timely and full disclosure in regard to those areas. And disclosure should include, but should not be limited to, just material information on the financial or the operating results of a company. There should be disclosure in relation to company objectives. There should be disclosure to the non-financial information as well. There has to be disclosure in relation to the major share ownership of the company, including the beneficial owners, who are the beneficial owners of a company, what are their voting rights, and so on. And one of the basic rights of investors, candidates, is to be informed about the ownership structure of the company and their rights vis-a-vis the rights of other owners. And the rights to such information should also extend to information about the structure of, say, a group of companies and the intra-group relations and so on. So such disclosures should make transparent the objectives, the nature, and the structure of a group, if it's a group of companies. So there has to be disclosure and transparent reporting, right? Which should be done accurately and on timely basis. Disclosure and transparency. It's a core principle for effective corporate governance as per the OECD. Then lastly, we have responsibility of the board. The board. Candidate, the board is a group of directors that is appointed by the owners of a company to manage the affairs of the company on behalf of the owners of the company. And corporate governance framework should ensure the strategic guidance of the company. The framework that is put in place should be one that ensures that the company is properly managed or guided. It should ensure the strategic guidance of the company, strategic guidance. That means giving long-term direction. There should be effective monitoring of management by the board and the board's accountability to the owners and also the shareholders. So an effective corporate governance framework is one that ensures that there is strategic guidance of the company. It ensures that there is effective monitoring of management by the board. All right? The management refers to the persons who are in charge of the day-to-day operations of the board. Those who are in charge of the day-to-day operations of the board should be monitored by the board. The structure, the corporate governance structure should also ensure that the board is accountable to the company and the shareholders. No one should be indispensable. No, there has to be a proper structure where the board is accountable to the owners of the company. The management, on the other hand, should be accountable to the board. So there has to be proper hierarchy. There has to be properly documented responsibilities and duties of the directors of the company, and together with guiding the guiding corporate strategy, the board candidates is also chiefly responsible for monitoring managerial performance. The board should ensure that the performance of the managers or the management is monitored. And it should also ensure that there is an adequate return for the shareholders while preventing conflicts of interest and balancing what we call competing demands on the corporation. And in order for boards to effectively fulfill their responsibilities, they must be able to exercise objective and independent judgment. That's why it's important when constituting a board of a company, then those who sit on the board, the majority of the shareholder, the directors should be ones that are independent. The board should comprise independent directors as well. They should be the majority so that the board can be seen to be independent, so that the board can give independent judgments. And another important board responsibility is to oversee the risk management system and the systems that are designed to ensure that the corporation obeys applicable laws, including tax laws, labor laws, environmental laws, equal opportunity laws, health and safety laws, and so on. So those are some of the responsibilities of the board, to oversee risk management. That's why some boards have set up risk management committees that can help the board in making decisions to ensure that the company does not engage in activities that could pose a risk to the going concern of an organization. So candidates, these are 6 core principles for effective corporate governance as per the OECD. That's the end of the lesson. Remember, we had only one objective, that by the end of the lesson, we should be able to summarize or explain the core principles for effective corporate governance as per the OECD. OECD. Here is your today's assignment. Summarize 6 core principles for effective corporate governance as per the OECD. Thank you for attending our today's session. We continue in our next session to study more on the chapter Introduction to Corporate Governance. Bye-bye.